Hello and welcome back to the January series. I'm Karen Salpe, professor of English here at Calvin, and today it's my pleasure to introduce our speaker, Jeffrey Rosen. Anytime during the hour, you're welcome to email questions for Jeffrey to askjseries@calvin.edu, and please be sure to put the question in the body of the message rather than in the subject header. Or you can tweet with the hashtag AskJSeries. We'll ask some of these questions near the end of the hour, if time permits. I want to thank both the Peter C. and Emma Jean Cook Foundation and the Henry Institute for the Study of Christianity and Politics for generously underwriting today's event. The last few weeks and days and months have been unsettling and unprecedented throughout the United States, and particularly in our nation's capital. Wherever we fall on the political spectrum, we have important things to think about and discuss, and it's for that reason I'm excited for us to hear from Jeffrey Rosen. He's president and CEO of the nonpartisan National Constitution Center, a nonprofit that educates the public about the U.S. Constitution. He also serves as professor at the George Washington University Law School, is a contributing editor at The Atlantic, has appeared in the New York Times Magazine, in the New Republic, in the New Yorker, and on NPR. Jeffrey was named one of the 10 best magazine journalists in America by the Chicago Tribune. He's a podcast host and author of 6 books, including the 2019 book, Conversations with RBG. That's the notorious Justice Ruth Bader Ginsburg, who passed away last September. How timely it is that he's with us today, helping us consider not only the role of the Supreme Court, but also the future of the Constitution itself. Welcome, Jeffrey. We're delighted to have you join us today.
Thank you so much, Professor Salpe. It is an honor to be here, and it was wonderful to talk to your great students this morning. I'm so looking forward to talking to all of you, Calvin University students, today about these 2 crucially important topics, the future of the Supreme Court and the future of the Constitution. As Professor Salpe says, what more urgently important topic could we be addressing than at this moment? Regardless of where we fall on the political spectrum, we can all recognize that we're living in unprecedented times. Never before in American history has an armed mob of citizens stormed the U.S. Capitol. And not since the War of 1812 has the Capitol been invaded. And each day in the news, we are seeing an avalanche of the most momentous constitutional questions, and for many of them, there are no clear precedents. The question of the day is, can a president who has been impeached by the House of Representatives be tried by the Senate after he's left office? A question that may arise next week is whether or not a president can be tried by the Senate. Can he be disqualified from holding future office under an obscure provision of the 14th Amendment, Section 3, which has not been previously invoked by sympathizers during the Civil War? Last week, we saw similarly momentous questions which arose, ranging from, does the vice president have any role to play in certifying electoral votes beyond the ministerial responsibility of opening the envelopes? Ultimately, Vice President Pence concluded he did not. Does the Congress have a substantive role to play in evaluating the legitimacy of electoral votes that have been certified by the Electoral College? Ultimately, both houses of Congress concluded that they did not, although there were some dissenting votes. And more recently, should the vice president invoke the 25th Amendment, which allows the vice president and a majority of the cabinet to certify that the president is disabled? Congress called on him to do that. He refused to do so. Friends, what's so striking about each of these questions that I flagged is that almost none of them were or will be ultimately be decided by the Supreme Court. They're all examples of constitutional interpretation by the political branches of government themselves, in particular Congress and the vice president and the state election officials, all interpreting the Constitution on their own without judicial oversight. Nevertheless, have had an important role to play in this historic election of 2020. In the face of claims of alleged fraud in the election, lower courts examined those claims, and 59 out of 60 judges appointed, many by President Trump, others by presidents of different perspectives, rejected those claims and found no such fraud. It was an inspiring example of nonpartisan unanimity on the parts of federal judges, regardless of the president who appointed them, examining the facts and evidence based on reason rather than passion, and concluding that they had no role to play in second-guessing the election. The U.S. Supreme Court itself was asked to intervene in the election and to re-examine, in particular, the certification of Pennsylvania's electoral votes, and the court unanimously refused to do so. Under the leadership of Chief Justice John Roberts, who has made the institutional legitimacy of the Supreme Court his highest priority as Chief Justice, all 9 justices agreed that it was not timely for them to intervene, and they, the Supreme Court, like the lower court judges, had no role to play in second-guessing electoral votes absent any convincing evidence of fraud. That Pennsylvania election case may be decided by the U.S. Supreme Court along with other election cases in the coming months. The decision will not affect the results of the 2020 election, obviously, but we may have some clarity from the U.S. Supreme Court on the crucial questions raised by that case. In particular, the question of whether Pennsylvania judges, by changing the rules for the counting of mail-in ballots and extending the deadline, violated the clause of the Constitution in Article 2, which gives state legislators plenary authority to determine the appointment of electors. So that's an open question, whether by simply interpreting its own election laws, state courts violate Article 2, as President Trump's lawyers argued, or whether state courts are not only allowed to, but required to interpret their own state election codes, which, after all, were proposed by the legislature and signed by the governor, and therefore that this doesn't raise any constitutional issues whatsoever. We'll see what the Supreme Court has to say about that question. Friends, what I'd like to talk to you about this morning is the duty. I know that's a stern word, but it's one that I think is appropriate today. The duty that you have as citizens to educate yourself about the complicated and open constitutional arguments on all sides of these important questions, and to make up your own mind. Before this week, perhaps you thought you didn't really need to study the Constitution, at least the cases interpreting it and its text and history. You're in college. Some of you may go to law school, but of course many won't. And you perhaps thought that was just a job for the judges. They would take care of it for you. Well, you see now that that's not the case, that the questions that the Constitution raises are so momentous and they're so open, and they're almost on both sides, that you really can't have an informed opinion as a citizen about what the Constitution requires until you've done some homework yourself. You've read the text. You read the leading historical incidents that gave rise to the provision at issue. You've looked at a couple of the Supreme Court precedents, if there are any. And you have also examined the arguments about how to translate amendments, written age, into a very different age, with questions that the framers could not always have anticipated. That's my mission at the National Constitution Center. As Professor Sauper said, we are a unique American institution created by the U.S. Congress to be the only nonpartisan institution in America dedicated to disseminating information about the U.S. Constitution to increase awareness and understanding of the Constitution among the American people. We've created a really inspiring web platform that I'd love you to check out. Not now, because I'm talking and with you, but after the show. It's called the Interactive Constitution, and you can click on any provision of the Constitution, the 25th Amendment or the Election Clause or the Impeachment Clause, and you'll find the top liberal and conservative scholars in America nominated by the Conservative Federalist Society and the Progressive American Constitution Society, with 1,000 words about what they agree that provision means, and then separate statements about what they disagree. Isn't that a wonderful resource? But when you read that 1,000-word statement, you can be completely confident that it's like a unanimous Supreme Court opinion. Leading scholars of different perspectives agree that every word in it is true, as it is. There's no dispute about either facts or opinion, because both have been so carefully discussed and deliberated. And then they also flag the areas for debate. In addition, you'll find a podcast that I have the privilege of hosting every week that Professor Sauper mentioned, where we convene liberal and conservative scholars to debate the constitutional issues in the news, as well as videos for middle and high school kids, public programs with Supreme Court justices of all perspectives, and a wonderful blog, which is nonpartisan and highly trafficked. What is distinctive about all of these platforms is they ask you, as citizens, to separate your political from your constitutional views. I'm a law professor. I teach law at George Washington University, and I always begin every constitutional law class by saying, let's separate our political from our constitutional views. What does that mean? Let's not ask what we think the government should do, but what we think the Constitution allows or forbids it to do. You see the difference? So if we're asking, we're talking about impeachment, as we are today. The question isn't, first of all, should the Senate convict the president? But first you have to ask the question, does the Senate have the power to try the president? It's like a jurisdictional question. And then you can ask, should the Senate convict? And in doing that, you would ask not whether you think what the president did was bad or good, not whether it necessarily met the legal standards for incitement, which are quite high. To actually incite violence as a federal crime, you have to intend imminent lawless action, and that imminent lawless action has to be likely to occur. That's a very high bar. But to be impeachable, an offense doesn't have to be criminal. There's broad agreement on that. It has to be just an offense against the public interest, a grave high crime or misdemeanor that threatens to undermine the rule of law. So you might decide it's not criminal, but it is impeachable. Or let's take a simpler example, very controversial but important, the Second Amendment. If we were talking about a Second Amendment question, I would ask you to ask yourself not if you think gun control is a good idea, but does the Second Amendment allow or forbid it? So you might think that gun control is a bad idea because the right to bear arms is really important, but this particular regulation is allowed by the Constitution. Or conversely, you might think gun control is an excellent idea because it's really important for public safety, but the Second Amendment forbids it. And by separating your political from your constitutional views, like a Supreme Court justice, you elevate yourself above partisan politics and are able to have respectful agreement and disagreement about this great document of human freedom, which unites us, the U.S. Constitution. That may sound like a 4th of July boilerplate before this week, but suddenly you know that I'm not speaking idly when I say the Constitution is the great document of human freedom that unites us. In the face of one of the greatest challenges to the Constitution in any of our lifetime, I'll call it the greatest challenge because we've not had the specter of armed mobs storming the Capitol. Violence against the institutions of government hasn't occurred in my lifetime in this way before, and in and I think in yours, because you're all younger than I am. In the face of this great challenge, the Constitution is carrying us through. It is providing a stable, peaceful, nonpartisan framework for discussion so that we can respectfully agree and disagree about the many issues that face the country without resorting to violence. That's the point of the Constitution, and that's why we're so blessed in the United States to be governed by this great document, the longest surviving written constitution in human history, which is triumphing and ensuring that reason rather than passion will prevail. That, after all, was the great object of the Constitution when it was framed in 1787. The framers had in mind the fear that armed mobs incited by demagogues would resort to violence. The paradigmatic case that they were afraid of was called Shays' Rebellion. It was an armed rebellion of debtors in Western Massachusetts in 1786 and 1787. They didn't want to pay their debts. There's a lot of inflation after the Revolutionary War, and they're storming the courthouses, which are enforcing bankruptcy judgments because they don't want to pay. And this is so alarming to the state legislatures that they call a constitutional convention to create a constitution that is strong enough to protect the rights of liberty, property, and self-government, but also constrained enough to not to threaten additional violations of liberty. That's why Madison in Federalist 55 is so striking. He says he's been reading a trunk full of books sent by Thomas Jefferson from Paris in the summer of 1787. And they're all about the failed democracies of Greece and Rome. And Madison is struck by the fact that those democracies, like in Greece, the 6,000 person assembly is misled by demagogues like Cleon, who are urging it to invade Sparta in the Peloponnesian War. And Madison says, in all large assemblies of any number composed, passion never fails to wrest the scepter. Even if every Athenian had been Socrates, Athens would still have been a mob. Remarkable, isn't it? Isn't that prescient? Those words just give us pause, because that's how afraid Madison and the other framers were that groups of citizens, if allowed to make hasty decisions inflamed by demagogues, would resort to mob violence. And that's why the whole purpose of the Constitution is to slow down deliberation, to prevent any group or faction, which Madison defines as a group, a majority or a minority, animated by passion rather than reason, devoted to self-interest rather than the public good. Factions are not supposed to be able to make quick decisions. You have to jump through a lot of hoops in the United States in order to have any branch of government allowed to speak for we the people. So for a law to be passed by Congress, you have to, it has to be proposed and passed by both houses and then signed by the president and then reviewed by the Supreme Court. Not until all those three branches have agreed can the law go into effect. Madison was confident that the large size of America would prevent mobs or factions from mobilizing, because the country was so big. By the time an armed mob like Shays' Rebellion tried to get more people to join, they'd get tired and they wouldn't be able to get support from another state, and eventually people would cool down or go home. Friends, obviously you're thinking, I'm sure, that things look very different today in the age of Facebook and Twitter and Instagram. It's not hard for passionate groups of citizens to discover each other. All you have to do is log on. And far from traveling slowly and giving passions a chance to cool, these armed factions or mobs can quickly crystallize or calcify or organize into filter bubbles and echo chambers, and then passions and conspiracy theories and violent sentiments that are crystallizing or formulating online can move offline, and then you can have the specter and spectacle that we just experienced on January 6th. So this is obviously a question of constitutional moment, how to create, how to resurrect the guardrails that the framers put in place and that may be being undermined by the speed of communications online. It's not an easy question. We should think through with it. We should start to think through it today. We all have responsibility as citizens to address this urgent question, and the National Constitution Center is committed to convening scholars and thought leaders and students and learners of all ages to think about what kind of guardrails could be resurrected to ensure the thoughtful, slow, Madisonian deliberation that ensures the triumph of reason rather than passion. But it's an urgently important question. You asked me, of course, to talk about the future of the Supreme Court, which has an important role to play in this in the constitutional system and represents, in many cases, not the only word on the Constitution, because as we've seen, all three branches have a responsibility to interpret the Constitution, but often the last word in constitutional interpretation. Let's think about the constitutional questions that the court is deciding this year, and also about the role of the court in light of the passing of Justice Ruth Bader Ginsburg. I do want to take a moment to pay tribute to her blessed memory. As Professor Sauper said, I had the honor of knowing her, of being her friend, and she allowed me to collect our many conversations over the years into this book, Conversations with RBG, which was published last year and which represents a tribute to the greatest woman I've ever had the privilege of knowing, not only a heroic advocate for gender equality, the most important advocate for gender equality of her time and of the 20th century, but also a role model about how to live, and the life lessons of Justice Ginsburg and her own remarkable achievement in being governed by reason rather than passion was moved by advice that her mother gave her, which she often quoted. Justice Ginsburg's mother, when she was very young, told her, "Don't be distracted by unproductive emotions like anger, jealousy, and remorse. They're not productive and they will distract you from the crucial task of serving the public." She had greater focus and ability to work and to tune out unkind words and unproductive distractions than anyone I've seen. She copy edited each page of the book even after she was recovering from cancer herself, and each word of the manuscript was marked up with her beautiful pencil edits. She was the most fearsome copy editor I've ever experienced. Typos corrected, spelling errors, and each word beautifully crafted to express her meaning as precisely as she could. She often cited advice that her mother-in-law gave her on her wedding day. Her father-in-law. It was Marty Ginsburg's father, who said, "Sometimes it helps to be a little deaf." And by that, Marty's parents meant, in a marriage, as on the Supreme Court, if someone says something unkind, if you're impatient, if someone speaks in anger, just tune it out. It's not productive. Keep focused, and eventually passions will cool and reason will prevail. It's, of course, hard advice for all of us to follow. Each day, we can get distracted, we can get impatient, we can get angry, we can allow our unproductive emotions to distract us from our task. But for me, whenever I'm tempted to surf the web rather than reading deeply, or get impatient rather than listening, I think of Justice Ginsburg, WWRBG, what would she do? And I try to focus and just do the work. So the passing of Justice Ginsburg, as did the balance of the Supreme Court. Justice Ginsburg told her daughter-in-law that her dying wish on her deathbed was that she not be replaced until the next president had been elected. She passed before the presidential election, but she thought that the next president should fill her seat. That's not the way things turned out. President Trump nominated Justice Barrett, and the Senate confirmed her, and Justice Barrett's now sitting on the court. And as a result, the conventional wisdom is that we have a Supreme Court composed of 6 conservatives and 3 liberals, because the 6 conservatives were appointed by Republican presidents and the 3 liberals by Democratic presidents. And therefore, the fear is that we're going to see many of the cases where Chief Justice John Roberts, who takes very seriously his responsibility to be a nonpartisan Chief Justice and to help citizens view the court as something more than the partisan compositions of the presidents who appointed them. In several important cases, Chief Justice Roberts had joined the liberal justices when Justice Ginsburg was on the court. For example, the most famous example is his vote to uphold the Affordable Care Act, where he provided the 5th vote with the liberal justices. And he also sided with the liberal justices in important cases involving whether or not you could add a citizenship question to the census. And the conventional wisdom now is that now that there's a solid 5-vote conservative majority, Chief Justice Roberts will have lost his ability to play that role of the swing vote, and there'll be a lot of cases that are overturned. What I want you to do is not accept that conventional wisdom, because if that's all that you think that the Supreme Court does, you're missing the many, many important cases where the justices do not decide cases based on their partisan affiliations and where they are moved not by their politics, but by their constitutional methodologies. They're doing just what I told you that you had a responsibility to do in approaching cases in constitutional rather than partisan terms. Let's take some of the cases last year involving President Trump's subpoenas. The district attorney, the U.S. attorney in New York, subpoenaed President Trump's financial records, and the court essentially unanimously said the president is not above the law and he's not completely immune from subpoenas in civil cases, although the justices disagreed about exactly what the standard for subpoenas should be. That was a triumph for Chief Justice Roberts' vision of nonpartisan adjudication. There were closer cases that were decided by unexpected majorities in a case involving whether the court could interpret Title VII of the Civil Rights Act to cover discrimination on the basis of LGBTQ status. That was a 6-3 decision written by Justice Neil Gorsuch, a conservative justice who cares a lot about the text of law. He's a textualist as well as an originalist. And because the text of the Civil Rights Act said there's no discrimination allowed because of sex, Justice Ginsburg says if you treat someone differently because of who they love, then you're discriminating because of sex. Even though Congress, when it passed the Civil Rights Act in 1964, didn't anticipate that that language would be extended to discrimination on the basis of LGBTQ status. So there's a great example of a justice being moved by his textualist methodology, not by his partisan politics, and an unexpected coalition of Justice Gorsuch and Chief Justice Roberts joining the liberal justices there. What about the most recent case that the Supreme Court decided just 2 days ago? On January 12th, the court decided Food and Drug Administration versus American College of Obstetricians and Gynecologists. You see me, I've got the case up here on my screen and I'm looking at it. And that was a case that hasn't yet been decided fully on the merits. It'll be decided later this year. But a district judge had issued a stay, which means an order saying don't do that, forbidding the Food and Drug Administration from requiring women who want to get a drug called mifepristone, which is an abortion-related drug. Basically, the Food and Drug Administration said if you want that drug, you got to pick it up in person. And the lower court judge says this is an undue burden on women's right to choose abortion because there are thousands of other drugs that you don't have to pick up in person, including opioids. There's been a waiver because of COVID, and you're allowed to get those by mail. And it's only this drug that the Food and Drug Administration says has to be picked up in person. And the district judge said there's no medical reason for this, and it imposes a great burden on women's constitutionally protected right to choose abortion. And therefore, it imposes an undue burden in violation of the right recognized in the 1992 case, Casey versus Planned Parenthood, which says that no regulation which imposes a substantial obstacle on women's right to choose abortion before fetal viability violates the Constitution. Now, the Supreme Court said the lower court judge was wrong to issue that stay, and it allowed the prohibition to remain in place. So right now, you do have to go in person to get that drug if you want it. Chief Justice Roberts, in explaining his vote with the conservative justices to lift this stay, said, generally, I think that judges should defer to administrative agencies. And if the experts in the Food and Drug Administration concluded that this regulation, which said you have to pick up the the medication in person was medically necessary. It's not the job of judges to second guess it. And then he said, I want to decide the case more fully after briefing and argument. There was a very strong dissenting opinion by Justice Sonia Sotomayor, joined by Justices Breyer and Kagan, who said there is no medical necessity for this one drug differently from 20,000 other drugs that you don't have to pick up in person. And Justice Sotomayor said judges do have an obligation to at least evaluate the evidence to see if it's convincing. And Justice Sotomayor agreed with the challengers that the evidence offered by the Food and Drug Administration was not convincing, and therefore there was no medically justifiable reason for treating differently than opioids and allowing it to be picked up by mail. So the court will decide the full case later this year when it hears arguments and issues a full opinion. But I went through all those technicalities with you because you can't make up your mind about whether you think the court was correct or not unless you take the time to review all those different steps. You understand that for Chief Justice Roberts anyway, because he told us in his brief unsigned opinion, the question wasn't should Roe v. Wade be overturned. The question wasn't should the Planned Parenthood v. Casey case be overturned, which says that you can't impose undue burdens on women's right to choose abortion. The question was should judges defer to administrators or exercise independent review of medical evidence. Now, I know it's asking a lot of you. You're not law students, and you all have limited time, as all citizens do, to dig in enough to these cases to educate yourself about the arguments on both sides. But you can do it. And it's really interesting to do it. And as I said, it's your duty to do it. And whether you want to accept your duty or not, your responsibility. And the framers thought it was your responsibility because they said, Thomas Jefferson said, a republic cannot survive ignorant and free. He said, unless citizens take the time to educate themselves about the Constitution, to listen thoughtfully to competing arguments, and to be guided by reason rather than passion, in effect, to exercise civic virtue, then the republic would collapse. What did Jefferson mean by civic virtue? It's actually the core. Wrote the Declaration of Independence. Isn't that amazing but surprising? When you read The Pursuit of Happiness, the modern understanding is that means do whatever feels good. But that's not what Jefferson and the founders meant. They meant do whatever is good. Be virtuous. Don't pursue immediate pleasure, but pursue long-term virtue. Because they believed, quoting all the great Greek and Roman philosophers, as well as the Enlightenment thinkers, that virtue is the foundation of happiness. That's what Jefferson said, quoting Epicurus, the great Greek philosopher. And what did Epicurus and Jefferson and Plato and Aristotle and John Locke and Francis Hutcheson and Philip Sidney and Algernon Sidney and all of these great classical and Enlightenment philosophers mean by virtue? They meant self-mastery, self-government, governing your unreasonable passions so that you can be guided by reason. That's what Madison meant in that quotation from Federalist 55 that I talked about. When citizens govern or master our passions, and that's the 18th century word for emotions, when we master our unreasonable emotions, our selfs, then we can be guided by our selfless or benevolent affections or passions, like loving our neighbor, like the golden rule, doing to others as we would have done to ourselves, like serving the public interest rather than our private, selfish interest. So suddenly you see that the project of self-government is not only political, but moral and psychological, that we have a duty to use the powers of our mind to ensure that our faculties of reason prevail over our unreasonable passions. And we cannot be happy as individuals or as a society unless we allow passion to be governed by reason. Pretty heady and heavy stuff, isn't it? But also, if you just think about it for a moment, it's true. It is the truth that when we are guided by our immediate selfish passions, our anger, our selfish desire for immediate gratification, it rarely leads to long-term happiness unless we, the modern phrase is, take a deep breath, unless we pause, unless we check our selfish impulses, it is on our long-term interest and on the greater good, we're likely to be misled in ways that don't serve ourselves or society. So that's why democracy is hard. And that's why the framers were not sure that the project would succeed. There's a remarkable moment at the end of the Constitutional Convention. Benjamin Franklin is walking outside, and a woman in Philadelphia comes up and says, "What have you created, Dr. Franklin?" And he famously says, "A republic, if you can keep it." And by that he means, if you can keep it, it's up to we the people, we the citizens of the United States, we the people of the United States, to preserve, protect, and defend the Constitution by mastering our unreasonable passions, by not allowing ourselves to get misled by demagogues and would-be autocrats and by passionate mobs, and to engage in the hard work of self-mastery, which requires deep reading, hard thinking, respectful deliberation, the ability to disagree without being disagreeable, and the humility to entertain the possibility that the other side might be right. Liberty is the spirit that is not too sure that it is right, said learned Hand in a famous and true speech. And unless you're willing to examine your own opinions with enough humility to listen to the other side and be open-minded to the possibility of changing your mind, then we won't be able to keep the republic. So that is why it's so important to study the Constitution. That's why it's so important for all of you, whether you are studying English or politics, like the great students I talked to this morning, or studying the sciences, or math, or any other topic. That's why I talk about kind of responsibility as a citizen and as a human being, just to take the time to learn and read and be guided by reason and educate yourself is necessary for personal and political happiness. I'll end. I'm really looking forward to our conversation. Happy to talk about any of the constitutional issues in the news. Goodness knows there are. So I'll just lay out the arguments for you on both sides, because there are rarely clear answers to them. But I want to leave you with a note of optimism during these incredibly challenging times, grave and serious threats to constitutional values. I'm inspired by the and depth of constitutional arguments. The fact that we have senators and representatives making serious arguments on both sides of these questions, taking their constitutional responsibilities seriously, recognizing and wrestling with the effort to separate their constitutional from their political views, suggests that the Constitution is prevailing and that it will continue to prevail. And for that, I am grateful to the genius of the framers for having drafted this great document of human freedom, and am confident that it will prevail. Thanks so much, and would love to take your questions.
Thank you, Jeffrey. Lots of questions coming in, and many of them asking you to comment on the Supreme Court's declining to hear cases related to the election result disputes. Could you help us understand, I know I'm asking we should go study the Constitution, but can you help us understand what's required in order for the Supreme Court to decide to hear such a case?
Usually, in order to agree to hear a case, the Supreme Court will wait for a disagreement between the lower courts on an important matter of constitutional interpretation. The Supreme Court hears almost very few of the cases it's asked to hear. It hears about 80 cases a year. It's asked to hear about 10 times that. And unless there's a serious constitutional dispute, then the court doesn't generally intervene. Serious constitutional dispute in any of the election-related cases. All of the courts that evaluated claims of so-called election fraud rejected those claims. So therefore, there was a unanimous agreement among the lower courts that the claims of fraud were baseless. And the broader question, the only constitutional question that the court may hear later this year, whether Pennsylvania in particular violated the U.S. Constitution, Article 2, when the Pennsylvania Supreme Court extended the deadlines for mail-in ballots, the U.S. Supreme Court decided, as Justice Alito suggested in his separate opinion from the decision not to fast-track the case, there's no rush. Basically, Justice Alito may have concluded it certainly wasn't going to make a result in a difference in the election result, because the only thing in dispute were 10,000 votes in Pennsylvania, which were not included in Pennsylvania's final tally. So even if the court ultimately decides that the lower court was wrong to change the deadline, it wouldn't have made a difference in the election, and therefore there was no need to hear the case fast. The other claims, like in the face of allegations of fraud, Congress has the power to throw out Electoral College certifications and make its own mind. The court thought were too implausible and frivolous even to entertain. So that's why legal observers on both sides of the aisle, except for the president's most ardent partisans, and I'm speaking here of his lawyers like Rudy Giuliani, thought the claims were frivolous, and indeed all the lower courts rejected them, and that's why the U.S. Supreme Court did as well. You know that I have to be nonpartisan at this point. This is just an issue where federal judges were unanimous, that there was nothing to the factual claims, and that's why they threw them out, and the Supreme Court didn't review it.
Thank you. There's never been probably a golden age in which Americans who differed on politics got along perfectly, but our current chapter feels really divided and polarized, especially in the last week. What can we learn from the friendship of Justice Ginsburg and Justice Scalia, so Ginsburg was a hero to the progressive left, and Scalia was a conservative icon and hero to many on the right? Can you comment on their friendship?
It was really moving. I didn't spend time with them together, although I did, talk to them separately. What really, what they bonded over initially was opera. It was the same thing that started my friendship with Justice Ginsburg. I'll just quickly share that I was a young law clerk in 1991, a long time ago, and I met Judge Ginsburg on the U.S. Court of Appeals in an elevator. She was coming down from an exercise class, and she was silent, and just to break the ice, I couldn't think of anything else to say. I said, "What operas have you seen recently?" I didn't even know she was an opera fan, but of course she is, and I am. And she just opened up, and we started talking about opera and developed this friendship. And the same thing happened with her and Judge Scalia. They became friends, bonding over opera on the U.S. Court of Appeals, where they served long ago. And then on the Supreme Court, they disagreed very strongly on many issues, but they were united by their shared love of opera, of good food, of laughter. Justice Ginsburg used to say, he drives me crazy, but he makes me crack up. She said, sometimes I have to pinch myself because I can't stop myself from laughing because he was so funny. And most important of all, their shared devotion to the institution of the Supreme Court and the importance of preserving its nonpartisan legitimacy. There is a great opera that was written about their friendship called Scalia-Ginsburg, and Justice Ginsburg's favorite aria in it was called "We Are Different, We Are One, United by Our Shared Love of the Constitution." And she said that she and Justice Scalia really believed that. At Justice Scalia's funeral, she told two stories. First, she related a story that I had reported as a young reporter in the New Republic magazine back when she was up for consideration to be nominated for the court, I had gone to the U.S. Court of Appeals. Justice Scalia had been there a few weeks before. This is while President Clinton was deciding who to nominate for the court. And the leading people on the short list were Mario Cuomo, Andrew Cuomo's father, and Professor Lawrence Tribe. And someone said to Justice Scalia, if you had to be trapped on a desert island for the rest of your life with Lawrence Tribe or Mario Cuomo, who would you choose? And Scalia said, without missing a beat, Ruth Bader Ginsburg. And I reported that in the Republican at Justice Scalia's funeral. Justice Ginsburg told this story and said, within weeks, the president chose me. So that vision of the fact that Justice Scalia suspected Justice Ginsburg helped convince President Clinton to appoint her. And she told one other story, which is that after the court decided Bush v. Gore, she was furious, outrageous usurpation of the Constitution, and she's sitting in her chambers, and suddenly the phone rings, and it's Justice Scalia, and he says, Ruth, what are you still doing at the court? Go home and take a hot bath. And she said, good advice, which I promptly followed. So even after on that day where they were so passionately divided in their interpretation of the Constitution, he was able thoughtfully to give her a ring and tell her to take a well-deserved bath. So it's so important to preserve that kind of friendship in different branches of government. It used to happen in the Senate, and President-elect Biden tells about how he was good friends in the old days when he started in the Senate with Republicans who strongly disagreed with him because the senators spent more time together and they were united by their shared love of the. That's fractured now as senators spend more time online or at home or raising money and less time actually just talking to each other. And because of the broader polarization in our society, which is often driven by online polarization. But let's all remember that beautiful friendship as a model for the way things can be and should be.
Thank you. We've been hearing so much from speakers in the past days about the importance of listening and trying to understand the other viewpoint. And I agree with you. When work communities are disconnected, it's hard to trust. And so there's an example of a friendship. I was all ready to ask you to recommend a political opera, and then you went ahead and did it, so I guess I'll move on. Can you comment?
I can recommend some more. Sorry, I can't resist, but since you...
Three operas,
a political opera.
Three operas, yes. Two.
Okay.
Two, in the interest of time, just two.
I can give more, but for the political opera, of course, the one to listen to is Beethoven's Fidelio. It ends with the most inspiring paean to human freedom, Freiheit, that has just ever been written. It'll give you goosebumps, and give yourself a treat by listening to Fidelio. And then you want another opera, and I always ask Justice Ginsburg what her favorite opera was, and she said it would vary depending on the day, but usually she came back to The Marriage of Figaro by Mozart. So friends, if you're not opera fans and haven't listened before, again, give yourself a treat. Just go onto Spotify or online and listen to The Marriage of Figaro, and you will hear sublime beauty and joy.
Thank you. I guess, as lockdowns and quarantines happen, maybe opera is a good way to fill that space, right? That and studying the Constitution, of course. I'll mention this again at the end. Just look up the Interactive Constitution, and this is the really wonderful document. You commented earlier that we have to do our homework. It's hard work to understand these things deeply. Here are two questions I'm going to connect. One says, in my understanding, justices have always had ideological leanings, but in many ways, the judicial branch is the most neutral branch of government. Do you see a stronger ideological split occurring in the Supreme Court that reflects a divide in our nation, and what is the danger of this? The second question refers to a recent article in The Atlantic by T.M. Luhrmann, who argues that Amy Coney Barrett may surprise people who expect ideological decisions. Luhrmann writes, what makes Barrett unpredictable is the possibility that she will interpret God as speaking in ways that she and the broader conservative world might not have anticipated. So can you comment on biases that justices bring to the courts and whether there's more of that apparent right now?
Great and important question. On the first point, has the judiciary been neutral? as I said, yes, I think we need to pause and give great thanks for the fact that in the face of this great challenge, there's been essentially unanimity among the lower courts and the Supreme Court about the election challenges, regardless of who appointed the judges, and that's a great blessing. Is there a danger of a more divided court? There is a danger. We've seen a few divided cases that might have come out differently if Justice Ginsburg had been on the court, and Chief Justice Roberts might have been able to achieve some greater consensus and narrower decision that avoided a constitutional split. One of them was the COVID shutdown order, which was 5-4, and the conservative justices said that churches shouldn't be treated like ordinary businesses, but should get an exception, and the liberal justices said they were being treated fairly and shouldn't get an exception. I'm just channeling or voicing the concern of Chief Justice Roberts here. It would be very bad for the country if we do see a series of 6-3 decisions decided along ideological grounds on the most contested questions of the country, including abortion, affirmative action, religious liberty, presidential power. As for whether Justice Barrett will surprise us, I haven't read that piece, and I can't tell from your description whether, I can't evaluate it, but I'm pretty confident that Justice Barrett will not decide cases based on what she thinks that God tells her, because she has said that she won't, and she, like Justice Scalia, believes that it is her oath of office. Her oath of office requires her to separate her personal and moral views from her constitutional views. Again, there may be more to that argument than I'm discerning from that one quotation, but regardless of how Justice Barrett comes down on some of the hot button issues where she may well differ from Justice Ginsburg, in particular, abortion regulations, where Justice Sotomayor quoted Justice Ginsburg in her dissenting opinion 2 days ago. And I don't have any doubt that Justice Ginsburg would have voted to allow that stay to remain in place. I am confident that Justice Barrett, like all of the justices, liberal and conservative, in many cases will surprise us, because they always do surprise us. And it is there are all sorts of examples every term of cases where the justices are unanimous, or nearly so. 80% of the cases of the Supreme Court are unanimous. And in so many cases, the justices are moved by their own methodologies to unexpected places. So although it's an important time for the court, and it's important for the court to rise to the challenge of not being a 6-3 court that allows citizens to question its nonpartisan legitimacy, I'm confident that in many cases, Justice Barrett will indeed surprise us.
There are several questions about your opinions about packing the court, the idea of adding justices to the Supreme Court. Can you comment on the implications of that possibility, if that were to happen?
Yes, let's think about the implications. Yeah, rather than my personal opinions. The implications, first of all, when I was a law student, I couldn't believe that Congress had the power to pack the court. And I had great discussions, arguments, debates with my beloved law professor, Akhil Amar, whose wonderful, brilliant work as America's teacher of the Constitution is just so inspiring. His book, America's Constitution, is a great place to begin if you want to begin deep study of the Constitution. That's also really accessible. But I said to Akhil Amar, that seems like a violation of the rule of law if Congress disagrees with the result of Supreme Court decisions, change its composition. But Akhil said, well, it's been done a lot of times before in the past. When the Jeffersonians were coming in, the Federalists changed the size of the court to deny President Jefferson the ability to make any appointments. Then the Jeffersonians take over, they restore the number of justices agreement. Then the size of the court fluctuates again around the time of the Civil War, when Congress allows the number to fall below 9 because it wants to deny President Andrew Johnson the ability to make any appointments, and then Johnson's out and the number goes back up to 9. So Congress does have the power to do it. Should it? Or the question is, what would the implications be? Well, I'm just speaking descriptively here. The Democrats say there are a bunch of stolen seats. Merrick Garland was nominated and not confirmed in a breaking of norms. The Senate may have had the power to do it, but that should have been a Democratic seat. And then Justice Ginsburg was replaced in another breaking of presidential term. So therefore, we're going to increase the size of the court so we can have our Democratic justices. Well, what would the implications be? It would mean that as soon as the Republicans took the White House and Congress again, they would change the size of the court and add more Republican justices. And the court would become a political football. And its ability to function as a nonpartisan adjudicator would be gravely threatened. Now, the people who support court packing say its ability has already been threatened by the fact that, it's been packed and therefore we're off and running. But the counter is that it would be very hard to step back from the abyss. Basically, there'd be no stable resting point in this nuclear war and really this treasure of constitutionalism. The fact our judiciary, for all its flaws, as we've been talking about, remains the most respected and the most nonpartisan institution, would be really gravely threatened. That's why even many Democrats, including President-elect Biden, clearly has some questions about court packing. He's kind of holding his cards close to his vest, but he's definitely not endorsed it. And that's, I'll just end this question by saying the Constitution Center recently sponsored a really fascinating project recently called the Constitution Drafting Project, where we assembled 3 teams of conservative, progressive, and libertarian scholars and asked them to draft constitutions from scratch. If they were just starting over, what would they do? Interestingly, all 3 teams decided to reform the Constitution rather than start from scratch. And 2 out of the 3 teams, and the third was open to it, the conservatives and the progressive, agreed on the wisdom of term limits for justices, 18-year term limits. They thought that if we were starting again, we wouldn't have life terms because people are living much longer than they did at the time of the framing. And they think the term limits for justices would ensure a fair rotation of justices with each president while also preserving judicial independence. In practice, that's hard to get through. You'd need a constitutional amendment, but it's a sign that there are folks on all sides of the aisle who are concerned about this question of the huge stakes of presidential elections because justices are living so long, and there are only 9 of them, but don't want to pack the court.
Thank you. 2 people asked that question as you were answering it, the idea of term limits. I'm not even sure how to ask this, but is it possible to be a truly originalist reader of the Constitution, in that you alluded earlier to understanding what the Founding Fathers meant when they talked about pursuing virtue, or the pursuit of happiness being pursuing virtue rather than individual pleasure. So then I wonder, what does it mean to be an originalist? Does that require contextualizing the document? This obviously comes up when we think about the right to bear arms. What were they thinking, and how might that differ from what we understand that to be today?
Well, I think what I'll say in response to this important question is saying you're an originalist doesn't settle any of the hard questions. And originalists disagree among themselves as much as they disagree with people who don't call themselves originalists. Justice Gorsuch disagrees with Justice Kavanaugh. Justices J. Harvey Wilkinson disagreed with Justice Thomas about the Second Amendment. The point is not that history is totally indeterminate. It's the question of how to translate principles from the framing into very different contexts. What the framers have thought about AK-47s, obviously they didn't think about that because we didn't have weapons like that. So you can identify what the paradigmatic concern of the Second Amendment was, and our interactive Constitution, liberal and conservative scholars say that the central concern was that an overpowerful federal government would disarm citizens from protecting themselves against federal tyranny. That's why they wanted to give citizens the power to organize themselves in militias to defend themselves against tyranny, and they were afraid that the federal government would take away their guns. that doesn't answer the question of what kind of regulations of firearms are consistent with the Second Amendment. And the answer to that question has more to do with how closely you scrutinize those regulations, what the lawyers call, are you going to give it something like strict scrutiny or a really close look, or you're going to give the legislatures more leeway? That question is not answered by the history. And in fact, you have some justices who want to look really closely at it, like Justice Thomas and Justice Gorsuch, and other justices who would call themselves originalists in other contexts, like Justice Scalia, who in the Heller case said that reasonable regulations are fine, who don't want to look as closely. So what I want to say to you is it's just a slogan to say, I'm an originalist, therefore I'm principled, and I'm separating my political from my constitutional views. It's nothing more than a description of a general approach and openness to be bound by text and history, but it doesn't guarantee any answers, and it doesn't preclude lots of disagreement. I can say, give me any constitutional question, I can point you to originalist arguments on both sides of the issue. So that's why this morning I noted that Justice Elena Kagan had said in tribute to Justice Scalia when he was alive, when she was dean of Harvard Law School, she said, we're all originalists now, in the sense that all judges, liberal and conservative, believe in the relevance of looking at text and original understanding as a starting point. They just disagree about what to do next, and calling yourself an originalist or not is not going to answer any of those hard questions.
Thank you so much for your insights, Jeffrey Rosen. Again, I want to encourage viewers to explore the Interactive Constitution online. It's a project generated by your Constitution Center. And one thing that impresses me especially about that site is the sections where opposing viewpoints have to write together about what they agree on. Thanks again to today's underwriters, the Peter C. and Emma Jean Cook Foundation, and the Henry Institute for the Study of Christianity and Politics. Thank you, Jeffrey, and thank you all for joining us today.
Thanks to all of you, and thanks for educating yourself about the Constitution.